Judgment in the appeals, McDonald and the Grid Electricity Transmission.
Lord Clerk will explain the judgment of the court.
Between 1954 and 1959, Percy McDonald attended Battersea Power Station in the course of his employment as a lorry driver for a firm known as Building Research Station to collect pulverised fuel ash. Between 1954 and January 1957, he was at the power station approximately twice a month, but this fell to about twice every 3 months from January 1957. While at the power station as a, quote, casual visitor, unquote, Mr McDonald went into areas where asbestos dust was generated by lagging work. The lagging work involved mixing asbestos powder with water in order to make a paste, as well as sawing preformed asbestos sections and stripping off old asbestos lagging. Mr McDonald was diagnosed as suffering from mesothelioma in July 2012 and sadly died at the beginning of February 2014. His widow, Edna McDonald, took his place as respondent in the appeal. The National Grid is the successor body of the occupiers of the power station. At trial, Mr McDonald alleged that those occupiers had been in breach of their statutory obligations under Regulation 2A of the Asbestos Industry Regulations 1931, the 1931 Regulations, and Section 47 of the Factories Act 1937, the 1937 Act. He also brought claims in negligence against the successors to his former employers and National Grid, but those claims failed and were not pursued in the Supreme Court. The trial judge dismissed all Mr McDonald's claims. On appeal, the Court of Appeal allowed Mr McDonald's appeal under the 1931 regulations, but dismissed his appeal under the 1937 Act. National Grid appeals to the Supreme Court in the first appeal, and Mrs McDonald cross-appeals in the second appeal. The Supreme Court dismisses both the appeal and the cross-appeal. On the appeal, the decision was by a majority of 3 justices to 2, with Lord Kerr giving the lead judgment and Lady Hale and myself giving concurring judgments, and with Lord Newburger agreeing with a dissenting judgment given by Lord Reid. On the cross-appeal, the decision was by a majority, with Lady Hale in the minority. As to the reasons, on the first appeal, the majority conclude that the 1931 regulations apply to all factories and workshops processing asbestos, not just those dealing with asbestos in its raw, unprocessed condition. The clear wording of the regulations indicates this, focusing as they did on the process in question rather than on the nature of the industry. The Secretary of State made the regulations to counteract the harm that could be done by the manipulation of asbestos, rather than focusing on any particular setting where this might happen. The mixing of asbestos during lagging work at the power station fell within the meaning of paragraph 1 of the preamble to the 1931 regulations. The Secretary of State was alive to the risk posed by mixing asbestos in settings other than a narrowly defined manufacturing context. Lady Hale points out that this interpretation of mixing is compatible with the decision of the Court of Appeal in Cherry Tree Machine Company Limited against Dawson UK Limited in 2001, which the Supreme Court unanimously approves in this case. Lord Kerr holds that a worker in a factory or workshop where processing of asbestos took place was within the scope of the 1931 regulations, even if he was not either mixing asbestos himself or directly employed by the occupiers of the premises where asbestos was being mixed. The Secretary of State made the regulations under Section 79 of the Factory and Workshop Act, 1901, the 1901 Act, which empowered him to afford protection to workers not involved in the asbestos processing. The risk of injury which those regulations sought to protect against arose from inhalation of dust or fumes. There was therefore no logical reason to exclude those who were liable to exposure despite not working directly with asbestos. Lady Hale concludes that liability under the 1901 Act was imposed on occupiers rather than employers to protect people in the premises they occupied. Therefore, the question was whether a person was employed in the power station, not whether he was employed by the occupier. As I see it, Mr McDonald was, in a real sense, working for the purposes of the power station, and I agree with Lord Kerr. Lord Reid, with whom Lord Neuberger agrees, undertakes an extensive review of the background to the 1931 regulations. They would have dismissed the appeal on the ground that the 1931 regulations were not engaged because they were intended to apply solely to asbestos processing within the asbestos industry. The regulations were penal legislation, they thought, which should be construed narrowly. Lord Neuberger, Lord Kerr and Lord Reid would dismiss the cross-appeal. They agree that while the rest of the statutory criteria are met, there is no sufficient evidence to rebut the Court of Appeal's conclusion that Mr McDonald had failed to establish that a, quote, substantial quantity of dust, unquote, had been given off by the mixing process, as required by Section 41 of the 1937 Act. For my part, I express no view on the cross-appeal. Lady Hale would have allowed the cross-appeal on the grounds that there is evidence upon which it could be determined that a substantial quantity of dust had been given off. Accordingly, the order is that the appeal and cross-appeal be dismissed.